All right, now I'd like to welcome to the show Susan Dudley, Distinguished Professor of Practice at the Trachtenberg School of Public Policy and Public Administration at George Washington University, and especially relevant to our topic today, former Administrator of the Office of Information and Regulatory Affairs under President George W. Bush. Welcome to Free the Economy, Susan.
Yeah, thanks for having me, Richard.
All right, so now we're going to talk about all things administrative and rules and regulations at the federal level. And we've just, of course, started a new administration here, and the Trump team has their hands on the controls of all this stuff. And President Trump, especially, people are already talking about signed a big stack of executive orders on his first afternoon back in office, and plenty of political observers debating all those topics. You know, either they're excited or they're dreading it, depending on where the political spectrum they are. But the what I'd like to start with is like a little bit of a process question here. So the president signs the orders that are in those little folders they put on his desk, but they don't magically enforce themselves, right? So when a new policy change comes through, uh, how does it get from the president's desk to sort of the rubber hitting the road in the real world?
Yeah, it depends on how the order is worded. So some of his orders just rescinded previous orders. You know, you know, that's one interesting thing about executive orders. The new president can sign them unilaterally with a stroke of a pen, but the next president can also undo them, so they can be undone just as easily. And they only guide the executive branch, so they can't bind the private sector or outside the executive branch of government. So what these orders often do is direct agencies to take certain action. And so that's where, as you say, the rubber will hit the road, is when the agencies take action pursuant to those orders.
Right. So I know in the case of getting rid of the diversity, equity, and inclusion offices and officers and task forces, we've already seen that the executive order was signed, and then the heads of agencies are sending emails out to their staff saying, by the way, we are ending these certain programs and we are reassigning these staff, or we're doing such and such. And so it's sort of up to whoever is running those agencies to, and their sort of leadership to say, okay, well, the president has told us we need to do X. And so now we're telling all of our downstream people we're
Mhm.
officially doing X here. Everyone gets the email. Although it's interesting because we're so early, a lot of those the cabinet departments and independent agencies don't have permanent secretaries or chairman yet, and so we're in this kind of in between phase where there's staff in place, but the principal isn't there yet. So that must be kind of a chaotic time if you're working on one of those sort of like transition team new agencies.
Yeah, I'm sure it is. And transitions are always chaotic. I mean, I'm always impressed at what does get done and how smooth they are. But I think there are some agencies that don't even have what they call the beachhead team, the
Mhm.
team that is there to be there at noon on January 20th to help things get started. So yeah, it's called a transition for a reason. It's a period of.
So, and you mentioned that some of these executive orders are, excuse me, some of these executive orders are what they call rescissions of previous executive orders. So, um, the new team comes in and says, "Well, here's the 10 things that the old team was doing that we don't want to do anymore." And because of Trump's unusual situation where he was president, he was not president, then he's president again. Um, there seem to be some of these day one executive orders rescinded a Biden executive order that had rescinded the Trump executive order uh, uh, from 2 terms ago. Normally, not something that happens because usually presidents serve their terms consecutively, and so this can be a sort of kind of merry-go-round. Um, but sh that doesn't seem to be something that, and I've heard people have criticized this, like why about doing so much policy change via executive orders that because they can be, thrown out the second a new president is sworn in, it makes it kind of tenuous to build a kind of long-term policy strategy on that.
Yeah, no, I think that's true. Executive orders are limited in what they can do. And one interesting question on this, I'm not a lawyer, and I've asked a lot of the smart lawyers I know, does when a president rescinds an order that rescinded a previous order, does that automatically reinstate the previous order? And I've gotten mixed responses, but I think that and one of the responses really only matters what the president thinks it did, because he's
Mhm.
the only one who can, um, require an executive order to be implemented. And just the reading that I've done, I think the intent of rescinding these orders was to reinstate the previous order. So, for example, in my world, which is regulation, that means Trump's Executive Order 13771, which called on agencies to set a regulatory budget,
Mhm.
to make sure that the costs of new regulations were offset by the costs of regulations removed, and that 2-for-1. I think that is still in place. Although, as you know, he's promised he's going to change that to 10-for-1. But as far as I can see, that has not happened as of Thursday when we're recording this.
Yes, and so, interesting procedure question about whether, getting rid of a rule or getting rid of an order that get rid of another order automatically puts the other one back in place. Although, if there's a question, the White House team could just reissue the old one again, I guess. Um, but it brings us to a really interesting question, which is, how these, you know, everyone's arguing about the content of these various rules, but what gets kind of talked about less is the process by which they're made in the first place, which then has implications for if they're challenged, or if someone sues over them, how durable they are, and ends up being sort of hashed through with the courts. Um, but one of those process ones, like you said, from the first term was the one in, two out, the idea that for every new rule, every new regulation that was promulgated under the first Trump administration, they would get rid of two old ones. And so that was a way, suppose, ideally a way of sort of making the government more kind of efficient and focused, right? If you want to create new burdens, because every new regulation creates some sort of, economic burden out there somehow, that you need to focus on the most bang for the buck in terms of, doing stuff that's important for the country, and moving from the the one in and two out to one in and 10 out, which the president, again, as we're recording, he just mentioned this again in his remarks to the World Economic Forum, um, is really kind of like supercharging that. Um, and like you said, I don't know, haven't seen that in an executive order that's like gone out, but it's announced. So presumably the policymakers in the new Trump administration are going to at least head in that direction, even if it hasn't been laid out in legalistic detail. Um, what how does that change the sort of the incentives and the process of being someone who works at one of these agencies that does make new regulations? It's got to be kind of really kind of turn your whole perspective around if you have to be thinking of a 10-to-1 trade-off.
Yeah. Um, I think that's right. I think it does change incentives. And I think what we saw last time with the 2-for-1 was, I'm not sure that we saw elimination of a lot of regulations. Not all your listeners might like this, but it was a bit of a gimmick, because
Mhm.
the way it was interpreted, and I think this was logical, was that only a significant new regulation counted as the one in, but you could remove two smaller regulations or guidance documents or other kinds of requirements would count for your two out. I don't think that's a bad thing, because as you say, if this is about incentives, it is worth looking at your whole, um, the accumulated regulatory requirements that you have, and even finding ones that may be small and removing them. I think so in addition to the 2-for-1, there was also a requirement for a cost offset, which was
Mhm.
probably more binding, because that is obviously more binding. Um, so it'll be interesting to see how the 10-for-1 is interpreted. Another question that I have is that OMB issued guidance pursuant to the 2-for-1 requirements. And if the order is still intact, is that guidance still intact?
Mm-hmm.
And that guidance, it told agencies how to do it, but it also encouraged them to look at the trade-offs in new regulations, the benefits as well as the costs when they were both eliminating regulations or modifying them and bringing new ones in. Oh,
Yeah.
so anyway, just one more thing on that,
Hmm.
that we'll see what it means for 10 for 1. I think if you look at the statistics, the data, the what we saw was the pace of new regulations slowed during the
Hmm.
Trump administration, even if the code of federal regulations did not shrink dramatically. And I think even the slowing of the pace of new regulations was beneficial to the economy. And I think we saw small businesses being more willing to invest and hire because they weren't worried about what new regulatory burdens might hit them next.
Right. And so again, in the sort of the transition from one administration to the next, there's a lot of it's a sort of like special moment for all these processes, and you wrote in your Forbes column about the transition from Biden to Trump at and this is the I love this headline: at midnight, some rules will turn into pumpkins. So what's the dynamic there?
Yeah, so that's interesting. So we saw President Trump issued a memorandum on his first day instituting a regulatory freeze. And he essentially said, um, don't send anything new to the Federal Register until the new policy team evaluates it. If there's something at the Federal Register, pull it back before it gets published. And we saw that actually. We saw a lot of rules that were there. And then the Office of Federal Register had a note that said this has been withdrawn. Um, and then for regulations that have been issued but that are not yet effective, delay that effective date if you can, if legal, for 60 days while the new team evaluates that and decides whether to repropose. So those are all the steps that he took. And actually, those are steps that every president, at least since Reagan, has taken. Usually it's the
Mm.
chief of staff who signs that memo to all department heads and agencies right after noon on January 20th. This time it was the president. I guess he likes to put his name on things. But it's a very similar memo with similar requirements.
Yeah,
So
so when it comes to like the Federal Register publishing new rules, you sort of just say stop the presses.
exactly. Yeah. Yeah.
And
And another way they might turn into pumpkins, and maybe this was your question, is use it with the Congressional Review Act. Do you want to
mm,
talk about that?
yeah, absolutely. So that's where like what we've been talking about so far is about just within the executive branch and things the president's directly in charge of. But um, with the Congressional Review Act, we have the chance for Congress to get involved and weigh in on things that sort of previous administrations done. So how does that process work?
Yeah. So for under the Congressional Review Act, regulations that were issued with less than 60 working days less left in the previous session. Um, well, actually, I should back up. The Congressional Review Act allows Congress to use expedited procedures to um, overturn or disapprove of regulations that are issued within a certain recent window. And if they didn't have enough time in the previous legislative session, then then the clock starts over again with the new a session. So in a couple weeks, that clock will restart. So there are several thousand regulations that were issued since that probably the date at which they get the look back date that they'll be
Mhm.
revisited is mid-August. So more than 1,000 regulations will fall into that. And several dozen of those are considered economically significant. So they'll have impacts of 100 million or 200 million or more in a year.
And it,
And
yeah,
go.
and sometimes it definitely seems like at the end of every administration, when they know there's going to be a change in party leadership, especially from a Democrat Republican president or vice versa, that agencies are in a hustle towards the end to get as many of the rules that they wanted to issue across the finish line bureaucratically. So there actually are even more in that like window than there might normally be.
Yeah, that's right. We us regulatory nerds will call that the midnight window. So the period between election day and inauguration day. So that 3 month period, there tends to be a dramatic uptick in regulatory activity. And we saw that this year, but we also saw a big uptick in April. And that was to avoid the possibility of Congress using the Congressional Review Act to disapprove rules. Because the earliest date, depending on, you don't really know the date until Congress ends for the session for the
Mhm.
year. But the earliest date would have been early May. And so the Biden administration, their biggest regulatory activity of their most significant regulations was back in April.
Right. And so the Commercial Review Act allows Congress to sort of overturn those regulations. They call it the resolution of disapproval, but they're not just frowning, they're making it not legally enforceable. Um, but the the Congressional Review Act also has this stipulation, which I'm not sure if this has ever really been litigated, the details of it, but it's supposed to stop agencies from implementing another sort of similar rule in the future. Right.
That's
So if
right.
we strike down one rule, you can't just come back a year later and put through another one that says the same thing. Um, and the question is, I think the language in the act is something like substantially similar or something. Um, but the question is, how similar does something have to be, right? It obviously can't be just any other rule on the same topic, right? Because that would that would stop the agency from doing any rule whatsoever under their jurisdiction. So it will be interesting to me. This would be something that would be happen to be would have to happen over years into the future if we had a Congress who disapproved of a regulation and it was struck down, and then uh, presumably a different administration implemented another one, and then someone sued and said, "Oh, well, you can't do that because Congress disapproved of this other similar one," and then it would have to be fought out in federal courts about what's too similar, um, and and the sort of the kind of the guidance that would come out of that sort of case, I think, would be sort of fascinating. Um, but so far, the we haven't had that many uses of the Congressional Review Act, really.
That's right. Yeah, it's been used 20 times. So it was first used in the transition from the Clinton administration to the George W. Bush administration. Um, and then after that, there was a 12-year lull. And then at the beginning, the transition from Obama to Trump is where we saw quite a few resolutions of disapproval. And then President Biden signed 3 resolutions disapproving Trump administration rules. So
Mhm.
you do see bipartisan use of it, certainly bipartisan introduction of resolutions disapproving rules. And you see resolutions that pass both houses of Congress, but then that joint resolution, when it goes to the president can veto it. So that's why we tend not to see it used except during transitions.
Right.
There are some unusual cases where it has. And I would say the reason that the Biden administration didn't use it, because I was head of the Office of Information and Regulatory Affairs at the end of the Bush administration. And despite my very best efforts, we issued some midnight regulations. And I'm sure there were some that the Obama administration would like to have tweaked, but they were concerned about that substantially the same.
Mm.
Um, that's quite a hammer. And so they were afraid if they signed a disapproval of one of those rules, they couldn't do something that was considered too similar to what the previous administration has done. So I think that's why we've only seen 3 signed by Democratic presidents and 17 by Republican.
Right. Now, it'd be interesting question, and again, a lot of speculation about how the new, speaking of the new executive orders, the new DOGE, Department of Government Efficiency, is going to play into all this. So there was a lot of kind of maximalist talk, I would say, from Elon Musk and Vivek Ramaswamy about how DOGE was going to be this entity that was going to somehow cut the federal budget, despite that's despite the fact that being Congress's job, and slash regulations and cut federal headcount and all these things. It looks like the administration is maybe dialing back a little bit expectations about what it's actually going to do. But one of the executive orders that Trump signed sort of quote officially establishes the Department of Government Efficiency and sort of lays out sort of general parameters of what it's supposed to be doing. And they mention things like implementing new software and procedures for federal agencies, which again is also a sort of more modest than what had been previously discussed. But the question is what what is DOGE? So it's not really a federal government agency in the traditional sense that like the Department of Agriculture or the Security and Exchange Commission is a federal agency, right? It hasn't been created by Congress, just by this executive order. And so Congress hasn't approved like a separate budget for it, right? Because it didn't exist when the last budget was passed. So what is it exactly? I guess is a question. But also, if it is, as some people suggested, oh well, it's a federal advisory committee. That's the sort of legal terminology for it. Then it falls under the Federal Advisory Committee Act, which is a law from the 1970s. It says if you have one of these sort of agencies, then it needs to have certain requirements about like transparency and sunshine laws and making its meetings public and publishing notes and all that sort of thing. Um, do you think whatever DOGE is going to become, is it going to be kind of a traditional federal advisory committee of like the kind we've seen plenty of times over the past few decades, or is it going to be kind of its own kind of sui generis thing out there that is not going to follow those kind of like transparency expectations?
Yeah, I really don't know. And I would have said something very different a week ago.
Mm,
Because as you say, it seems to have narrowed in scale, and the executive order on DOGE rebrands an existing White House office that was the Department of Digital Services that apparently was set up. I hadn't been aware of it before, but it was
mm,
apparently set up during the Obama administration when the Affordable Care Act exchange system was being rolled out with so many problems. And so it
mm.
was set up there. So my understanding of it is it's temporary government employees who are involved that are, and according to this executive order, their mission will be to modernize software, improve technology, which is probably important. But it's much narrower than we had heard that DOGE would be. Now, that might get around the FACA objections because, as you alluded to, there were lawsuits filed right away that DOGE was violating FACA. Which may have been premature because we really didn't know how it was structured yet, and I think we still don't. But if all of DOGE is encompassed in this new department, it probably does not violate FACA, but it would be temporary government employees that are dispatched to work with agencies.
All right. Now, um, so obviously, like we said, like with the executive order sort of rescinding previous things, and then the question of Congress getting in the act. The Trump administration, I'm sure, has lots of rulemakings that happen under Biden. They would be looking to reverse or change or amend. But for regulations that went through the sort of traditional process, where we call that notice and comment, where you publish a rule and they say we're taking comments on it, and then the comments come in, and the agency is required to like look at the comments and respond to them, and before they issue a final rule, that whole kind of long process. If you want to change a rule that was implemented that way, unlike an executive order, you need to sort of go through that process again, and that can be long and complicated. And then courts will want to know, well, why did you change it, and did you have a sufficient reasons for changing it? Um, so, what what do you think the prospect is for the Trump team being able to actually reverse a bunch of those notice and comment regulations? Are they going to have the bandwidth, just leadership staff wise, to change a lot of the Biden stuff? Well, also because of course they've got original new policy ideas of their own they want to implement, right? So how, when you have a new administration like that, you know, how does an agency head prioritize those two things, right? Because you could spend 4 years doing nothing but trying to undo all the other old rules and never get to your new agenda.
Yeah. Yeah, as you say, it takes as long to undo or to revise a regulation as to issue it in the first place. Um, and so they're going to need to be disciplined and do their homework if they want to. So I think you're right about prioritizing will be important. And Trump's executive orders, some of them talked about specific regulations that should be reconsidered, revisited. Um, so yes, you need to develop a record that will survive in court, and you need to take that public comment and take it seriously, so that it'll survive in court. And we had some very interesting cases that came down in 2024, including the Loper Bright case that reversed the longstanding Chevron deference to agencies' interpretations of their statutes. And in some, I think that could go both ways for the new administration, because if it's going to be harder for them to reverse a regulation using new legal analysis unless they really are tracking the statute better than the Biden administration or whoever issued it the last time. So I think, um, in some ways, if there was a, if it was a stretch at what the proper interpretation of the statute is, I think courts will defer to the new administration. But if it's a long-standing interpretation, I think it may be hard to change it with the new interpretation of the law. And that was one of the things that the opinion observed, that we see these wild political swings with one administration saying the law tells us to do this, therefore we're doing that, and the next administration saying, no, it's telling us to do not this, and going in a different direction. And some of us hope that the Loper decision will reduce those wild swings and tie it closer to what Congress required. But that may well make it harder for the Trump team to change regulations.
Well, yeah, and in that case, I feel like you know, so as with overturning old regulations, like we said, we have the Congressional Review Act process where under certain restrictions, Congress can come in and say, you know what, that rule that the previous administration passed, we're just invalidating it. It's done, and you can't come back with a similar one in the future. Um, because the sort of deregulatory process is also complicated, like we just talked about. Um, I feel like the one option there is for the Trump people to go to Congress, and that now thin majorities, but some Republican majorities in both houses, and say, well, trying to do the deregulation we want to do via the traditional rulemaking process, the notice and comment process, is going to take too long, and without deference to our new opinion, our new agency action, maybe it'll be harder to get it to stick legally. So Congress, why don't you just change the relevant statute and tell our agencies they can't do, or they have to do it differently? Because I feel like in most administrations, the agency heads would want Congress to give them, more authority and more budget and, more staffing. But in this administration, maybe they would welcome Congress abolishing their agency entirely, right? I think President Trump said to Linda McMahon coming in as Secretary of Education something like, "Oh, if she does her job right, she'll be the last ever Secretary of Education," right? So you have a weird set of incentives where there seem to be a lot of like smaller government people in the Trump team, and so they would want actually less power for some of the agencies.
Yeah, well, good luck with getting Congress to do that. Now we did see it in the um, 70s leading into the 80s with the Civil Aeronautics Board and the Interstate Commerce Commission. Whole agencies were abolished. And that was bipartisan. There was bipartisan support for that. But I don't know if I'm just dreaming about better times, but it's hard to see enough bipartisan support to pass new legislation that would clarify some of these questions, the authority questions. Now,
Yeah.
one more thing that the new administration could do, we've talked about working with Congress with the Congressional Review Act, but there also are the courts. And to the extent that there's litigation over an agency's regulation, how the Trump administration, the agencies and the Department of Justice respond to those cases also can change regulations. So instead of the Biden Justice Department defending a regulation, the Trump Justice Department might say, you know, Judge, these folks have a point. Why don't you let us negotiate a settlement or let us go back to the drawing board and revise this regulation accordingly? So that'll be interesting to see. But again, that takes discipline and thoroughness.
Yeah, I guess that's an interesting question too about there are so if you just look at from like the partisan politics standpoint, there appears to be this huge dividing point, right, between one administration and the next. But the new administration would, in any transition, inherits all sorts of things, including, dozens, hundreds, thousands of ongoing lawsuits on at all levels and all agencies, and the when it's handed over from one person to the next, well, the attorneys, the counsels for the new administration may have a very different perspective on how they want that case to go than the previous one. So even though it's this, it's the same lawsuit, right? The caption's the same,
Yeah.
Smith versus Jones, it says it's got the same names on it. Um, the the way the new people in charge are sort of handling that might change dramatically. I think when Mick Mulvaney was director of the CFPB, he again he was technically an agency director that I think would have been happy to have his agency at the time abolished entirely. Um, the CFPB had a bunch of lawsuits in process at the time, and what the summary of what I read about it was that he basically just said, "Look, we're going to settle all of them for $1." We just and then that's it. And of course, and all the people who were being sued by the CFPB said, "Oh, well, we accept the CFPB's $1 settlement," and then they just sort of like all the cases went away, basically. Um, like he couldn't unilaterally sort of dismiss them, but that was just the solution, and then they moved on. So that's sort of possible. I know my distinguished former colleague at CEI, Chris Horner, who's a very smart attorney, who's written mostly about energy and environment stuff. Wrote a Wall Street Journal op-ed months ago now saying that the Trump administration, if they are on the receiving end of having to defend a regulation they don't like and they don't really want to defend, they could sort of confess error in
Yeah.
court and say, look, we, the federal government, i.e., the Biden team, we erred, we made a mistake, and we're admitting to it now, and so we're no longer pursuing this rule, and specifically said that the most effective strategy is to say that it was a pretextual, another one. So
Right.
the idea that like you advanced a rule under one rationale when it was sort of secretly trying to achieve this other thing, and that's not allowed. And so the rule against pretext, because the previous team wasn't sort of honest enough about their real policy objectives, and that could lead a judge to say, okay, well then we'll just this will not be allowed either. Um, and as always, we've got a big mix. Everyone always wants to know, well, who's going to hear these cases? Who appointed them? Was a Republican or a Democrat? And so we've got a big federal judiciary, and there's lots of Democrat appointed judges, a lot of Republican appointed judges. So it's a mix, and often a lot of these things are randomly assigned. So there's no way to know ahead of time who will, which judge will get which challenge, and there's lots of both. So we'll just have to do the novel thing and actually assess them by the strength of their arguments, rather than assuming any Republican appointed judge is going to be pro-Trump, or vice versa. Um, so we've had kind of a blizzard just in the first week. It's sort of like that when decades worth of history happens all at once in the same week. So it is difficult to make predictions, but do you have any sense about where, again, because there's, Trump is controversial, he's sort of a famously divisive figure, and there's a lot of sort of, left-wing, progressive, liberal advocacy groups and public interest law firms that are lining up to, challenge the stuff that the Trump administration is doing. But, there's only so many left-wing lawyers, even in Washington, D.C., right? And so the people who are wanting to slow Trump down, they're going to have to pick their targets too. So, you know, because we've had, a handful of these, high button issues going back, 10, 20 years, things that really get highly litigated, a lot of the immigration stuff, now citizenship stuff, I'm sure will be on that list. Do you have a feel for what Trump stuff is probably going to kind of just flow forward, and which stuff will be just in litigation for a decade?
I don't. Um, and some of the one of the executive orders, at least maybe more than one, was focused on energy issues,
Hmm.
including permitting issues and streamlining permitting. And I know Trump's, Trump's energy strategy probably is not popular among a lot of people on the left of center people, but the idea of improving how permitting works could be something that has some bipartisan support.
Hmm.
So that just to reduce the delays in getting things done. But I don't know. I do look back to the 70s and 80s and the bipartisan support there for removal of the types of regulations that it was becoming more clear that they were harmful. And
Hmm.
it was academic research. I mean, it was, real world evidence and academic research that showed that. It showed that the types of regulations regulating prices and who could participate, what airlines could fly, what routes, et cetera, that it really ended up harming the consumers. And so that appreciation, and then the policy entrepreneurs in all branches of government led to deregulation. So we recently um, honored Jimmy Carter a couple of weeks ago. Um, Jimmy Carter, I wrote an article, Jimmy Carter, the Great Deregulator, when he
Hmm.
went on hospice, because he is responsible for initiating a lot of the deregulation that led to real prosperity and economic growth and huge social gains, including the cell phones that we all depend on so much right now.
Yeah, that's a great story that I think always surprises some people where, you know, history sort of remembered Ronald Reagan so much as the sort of, small government kind of guy and regulatory reform kind of guy, but a lot of, as you point out, a lot of those big structural reg reform changes in airlines and rail, the railroad industry, and a bunch of other ones were that energy really started with the Carter team before the Reagan Revolution was even in office.
Yeah.
Um, so who knows? We may even in our very polarized time, we may find regulatory reform options that will attract bipartisan support, and that is a wonderfully optimistic way, I think, to wrap up this conversation. Not as optimistic. I had a conversation a couple episodes with Jim Bovard, and he was not as optimistic about about what we're going to see going forward. So we're gonna balance things out. Um, well, Susan, thank you so much for being with us and giving us the benefit of your great expertise.
Well, thank you, Richard. I enjoyed it.
And before we go, where should people find you, your research, your academic work
Oh,
online?
yeah, thank you. So, I founded the George Washington University Regulatory Studies Center about 15 years ago, and we have a wonderful new director, but I'm still there as a senior scholar, as well as you noted, on the faculty of the Public Policy School. So regulatorystudies.gwu.edu, and we've got a lot of interesting material there, including statistics on regulations over time. So you can see a lot of different measures of the growth in regulation over time. And for people who are interested in the Congressional Review Act in particular, we've got a dashboard, a CRA dashboard, where you can look and see which regulations would fall into that window that Congress would have an opportunity to disapprove.
Mhm. Oh yeah, that'll be very. A lot of people are going to want to look that up over the next few weeks and months. All right, thanks again, Susan.
Okay, thanks, Richard.